My name is William Haun, and I'm a non-resident fellow here at the American Enterprise Institute. Just as a preparation for the question and answer period of tonight's discussion, for folks watching us online, you can tweet questions to us at hashtag AEI Religious Liberty, or email them to sophie.rizzieri@aei.org. We're here tonight given this fascinating new book from Notre Dame professor Vincent Phillip Muñoz entitled Religious Liberty and the American Founding, Natural Rights and the Original Meanings of the First Amendment's Religion Clauses. Before we get to the beginning and the core of the book, I actually wanted to briefly comment on something that's mentioned in the acknowledgments. Professor Muñoz notes that he lost a great friend and mentor in preparing for this book, and a friend and mentor to everyone on the stage, and that's Michael Ullman. And as Michael passed away about 3 years ago, this past October, and it is the month of November, I thought it would be appropriate to just begin with a moment of silence for Michael, who I'm sure would have loved to have been here. Thank you for that. At the core of this book is a very bold claim, and that is essentially this, that for as much as the current Supreme Court is adopting a history-based jurisprudence across the Constitution's guarantees, but particularly toward the First Amendment, for as much as, to quote Justice Elena Kagan, we're all originalists now, and for as much as these concepts are informing the court's religious liberty cases generally, according to Professor Muñoz, it turns out that none of these developments bear much resemblance to the original natural rights understanding of religious liberty that was generally held by the founding generation. And in support of that claim, Professor Muñoz has provided an extensive analysis of the founders' political philosophy, the underlying theological ideas that permeated American life at the founding, and a careful, meticulous review of the ratification history under both the First Amendment's establishment and free exercise clauses. This analysis makes it a very interesting read. But perhaps more important than it being interesting, I think it's admirable. And I say that precisely because, frankly, I don't agree with the conclusions. While tonight I am your moderator, I think in the spirit of candor, it's worth noting that during the day, I litigate the very religious liberty doctrines that Professor Muñoz disagrees with. And he is up front on page 1 of the preface, no less, that for all of the analysis, he does not favor some of the results that implementation of some of the theories in this book would produce, and that some of the implementation might even undermine current religious liberty guarantees. That candor, that intellectual honesty is always commendable. And I think it's especially commendable in our current political and legal culture. So it makes it a particular privilege for me tonight to have this conversation with Professor Muñoz and also with John Yoo. And so to give them just a little bit more of an introduction, though they surely need none, Professor Muñoz is the Tocqueville Associate Professor of Political Science and concurrent Associate Professor of Law at the University of Notre Dame. He is also the founding director of Notre Dame's Center for Citizenship and Constitutional Government. He's an award-winning teacher and has been cited by multiple Supreme Court justices, and he has taught extensively and published extensively on the Constitution. As I said, we also get the benefit tonight of being joined by John Yoo. John is an AEI Senior Visiting Fellow here, and in addition to his service at AEI, he is the Emanuel Heller Professor of Law at the University of California at Berkeley. He's a widely published scholar on all matter of constitutional law, a former Justice Department official, and a former law clerk to Justice Clarence Thomas and Judge Lawrence Silberman. In terms of a format for tonight, we'll begin with having Professor Muñoz just articulate in about 10 minutes just the overall thesis of the book, followed then by a response from Professor Yoo for 10 minutes. Then we'll have a discussion up here, and we'll open it up then afterwards to audience and any internet Q&A. So without further ado, Professor Muñoz, we look forward to hearing from you.
Thank you. Thanks so much, Will, and thank you especially for those the kind tribute to Professor Ullman.
Michael Yeoman was a teacher of mine and a great friend and mentor, and I'm deeply appreciative of that. Thank you to AEI, Yuval Levin, who's this panel was his idea, so thank you, Yuval, and of course, John Yu, thank you for your presence here and your comments. And let me just start with a story. You mentioned that I'd been cited by the Supreme Court. The last time I was cited was by Justice Alito in the city of Philadelphia versus Fulton. And for a law professor, I teach in law school as well as political science. For a law professor, a Supreme Court citation is, it's a big deal. So I was getting all these texts, congratulations. I got a note from the dean of the law school. They put it up on the law school website, and they're like, Justice Alito cites you multiple times, and isn't that great? And I'm laughing because I'm like, you didn't read the opinion. He dedicates a whole portion of his opinion to explaining why I'm wrong. So yes, but citations are not always necessarily complimentary. Okay, so Will asked me to speak for 10 minutes on the book. It took me about 10 years to write the book, so this is a painful assignment. I'm going to do the best I can. The question of our panel is, what would an originalist account of the religion clauses look like? There are different varieties of originalism, of course, but all originalists, I think we can say, start with the text, the Constitution's text. So for the First Amendment religion clauses, every originalist will ask, what is the original meaning or public meaning of an establishment of religion? And what did the founders mean to do when they prohibited that? What's the original public meaning of the free exercise of religion? These terms, it turns out, are not self-evident. They're not terms of art. So it's not clear just by reading the text what an establishment is or what the free exercise of religion is. So most originalists then will turn to the historical record, in particular the drafting record. What can we learn about when we read the historical record, the drafting and the adoption of these clauses? In the book, I devote a chapter each to the historical record of the Establishment Clause and Free Exercise Clause. They are admittedly painful chapters to read. They're very detailed. They're really meant for the lawyers and judges. And I try to go through the historical record as carefully as one can. I think there are some new things, constitutional historians, new things I find, but the main conclusion I reach after going through everything I can find on the historical record is not really a happy one for originalists. I find that the historical record doesn't actually give us a clear public meaning of what an establishment of religion is or what the free exercise of religion is. The text is underdetermined. That poses a real difficulty for originalists. If you're supposed to understand the original meaning of the text and apply it, and there is no clear original meaning to find, what do you do? Where do you go? This is true of the Free Exercise Clause, I find, and of the Establishment Clause. So my first argument is you have to go beyond the text to interpret the text. So where should an originalist go? Non-originalists have no problem with this. They go beyond the text all the time. To interpret the Constitution, they typically look to contemporary progressive values, which just coincidentally happen to be found espoused by Ivy League professors. But that's not what an originalist is supposed to do, even if you have a fancy Ivy League degree like Professor Yu. An originalist is supposed to
Degrees plural.
An originalist is supposed to uncover and apply the text's original meaning. So again, originalists, at least in this case, and these cases, have a problem. The solution I propose in my book, and obviously I'm simplifying somewhat, is that originalists need to be more capacious than they have been in the past. And they need to read the Constitution in light of its original design and especially its original purposes and principles. The Constitution, at least in the founders' understanding, was adopted to secure our natural rights. And in particular, when the founders discussed religious liberty, they said religious liberty is an inalienable natural rights. So my argument is that an approach to the Constitution consistent with the original governing philosophy, the original purpose of the Constitution, would construct the First Amendment in light of America's original natural rights political philosophy. And that's simply what I try to do in the book. I simply try to present, this is a natural rights account of the First Amendment. And I appreciate Will mentioning that, and I say this in my preface, the book is meant to be a work of scholarship. This is what you get if you apply natural rights political philosophy to the First Amendment. It doesn't matter whether I like it or Will finds it useful. I'm just trying to present the argument. And my underlying argument there is we can't argue whether a natural rights approach is a meritorious approach or not a meritorious approach until we understand it. So first let's understand it and present it, and then we can have arguments about it. Okay. Just very briefly, in the first section of my book, I devote a chapter to the pre-1787 state constitutions. And I do this to document that the founders conceived religious liberty as an inalienable natural right. Just a word on this. It's an account of historical documents. There's a treasure trove of underappreciated documents. When between 1776 and 1787, most of the states, not all, but most of the states drafted new constitutions. And many of the states, 8 states at that time, attached declarations of rights prior to the constitutions. These are not the same as a Bill of Rights. Technically, they're not really part of the Constitution. They're statements of political principles. They're like the preamble of the Constitution or even the Declaration of Independence. And they're a rich source of evidence to document what the founders thought about constitutionalism, the ends or purposes of constitutionalism. And when you go back and read these documents, what you find is they all talk about natural rights, social compact theory, government, all men are created equal, government is, legitimate government is via consent, and they almost all talk about the inalienable right of religious liberty. So then I devote a second chapter to explaining the founders' social compact political theory of government. I try to explain, it's really elementary political ideals of the founders, concepts of the founders, but just to take one example, the founders talk about inalienable natural rights and alienable natural rights. So there's actually a difference between, there's 2 types of natural rights. They're both natural, but they're different. I try to explain what that difference means, and I'll talk a little bit more about that later. I'm sure we'll talk about it in the Q&A. One other part from the first part of the book, I try to present the founders' philosophical and theological reasons for saying that religious liberty is a natural right, an inalienable natural right. Now, this goes beyond the purview of jurisprudence in particular, or applying laws. But the reason I do this is because I'm trying to explain the founders' principles of justice. Why do we have an inalienable natural right to religious liberty? And what you find is that there are founders like Jefferson who used, say, secular or Enlightenment philosophy. There's founders, very influential founders like Isaac Backus, who's my case study. He's a very influential Baptist preacher in Massachusetts, probably the most influential Baptist preacher at the time of the founding era. He reached the conclusion that we have natural rights through biblical interpretation, through theological reasoning. And then there are founders, or a founder like James Madison, who gave a natural theological or philosophical account of natural rights. The founders had reasons for their arguments about religious liberty. One of the reasons I think is important to this, I mean, originalists tend to say, well, we just need to know what the original meaning is. But I suppose I'm a different sort of originalist. I want to know if the original meaning is good, is just. And to have that conversation, we have to understand the founders' philosophical and theological reasons for their claims about natural rights. Okay, so what would a natural rights approach to the First Amendment look like? What results does this approach produce? Well, it's a series of results that makes no one happy. For the free exercise clause, the book's key argument is that the founders' conception of an inalienable natural right is jurisdictional. The founders held that we the people do not grant government authority over our religious exercises as such. This lack of authority means that government can't punish, prohibit, mandate, or regulate religious beliefs as such. And the as such is important. I mean, you can't target, you can't say you must go to Mass on Saturday or you cannot go to confession, Catholic confession. It's targeted legislation. In the natural rights construction, the free exercise clause would prohibit a law that prohibits or directly regulates religious exercises as such. And this prohibition would be categorical. For the lawyers, that means no compelling state interest, no least remittance. Government simply can't do it. Government can't do it because it doesn't have authority, because we, the people, never gave it authority, gave the government authority over our religious exercises. This approach would not provide a constitutional right for exemptions for religious individuals from otherwise valid but burdensome laws. I'm sorry, Will. Natural rights originalism would not support the approach taken recently by Justice Alito, Justice Thomas, and Justice Gorsuch in Fulton versus City of Philadelphia. Okay. The approach would also be different from Justice Scalia, the one he advocated, and Chief Justice Roberts, insofar as they read the Free Exercise Clause as a non-discrimination provision, no discrimination against religion. You might reach non-discrimination in other ways, but not through the Free Exercise Clause. So the natural rights approach is much more limited and much more focused. Part of my argument is that this particular constitutional text had a particular function. Right? Now that function will seem small or limited from our perspective today, but in the history of government, to say that government cannot regulate religious exercises, that's a revolution in constitutional government. And I think we forget how revolutionary the founding was in that sense. Conservatives often talk about small government and limited government as if they're the same thing. Small government is just less taxes and all the things that are generated, policy proposals that are generated in this building. Limited government is there's certain things that government can't do. And the first limit on government is it can't tell you how to pray or punish you for praying. That is a revolution. That is a new order for the ages. The Free Exercise Clause is meant to communicate that prohibition. Okay, for the Establishment Clause, the translation from natural rights theory to a constitutional doctrine is a bit less direct. But if we consider what we can gather, again, about the text's original design and purposes and the actual words that are adopted, the construction of the Establishment Clause, consistent with the founders' natural rights political philosophy, at least in my interpretation, would prohibit what I call state establishments and church establishments. A state establishment is when government exercises itself the functions of a church, or when it says these are the tenets that churches must have, these are how you must select your ministers. Church establishments are when government delegates its coercive authority to a church, especially in matters of taxation and financial contribution. Let me just pause for a moment here. There's great evidence that, for reasons I don't understand, has never been used by the Supreme Court or appellate court justices. There's only one establishment of religion in the founding era. Everyone says there are 6 or 7. That's wrong. Right? Everyone says there are 6 or 7 because of a very influential historian, Leonard Levy, said there were 6 or 7 back in the 60s. Leonard Levy said there are 6 or 7 because he said, well, if government funds religion, that's an establishment. But if you go back in the record, that's not at all obvious. Provisions about funding are completely separate from provisions about establishments in the state constitutions. In fact, there's only one state constitution that established a religion. 1778 South Carolina State Constitution said the Protestant Christian religion is the established religion of the church. So if you want to know what if you're an entrepreneurial judge, appellate court judge, and you want to say what an establishment of religion is, turn to the 1778 South Carolina Constitution. And that Constitution did some very interesting things. It had 5 official tenets of faith that all churches had to subscribe to if they wanted to be incorporated. That is, and you couldn't own property unless you got an incorporation. It prescribed an oath of office for all ministers, and it prescribed how ministers are to be selected. It also gave the state authority, it gave the state's authority to establish churches to effectively tax their members. So it was a delegation of state authority to churches. That's an establishment of religion. Right? And I try to capture those improper relationships between institutional churches and state authorities by the terms church establishment and state establishment. So the Establishment Clause was designed to prohibit government establishing religious doctrines or regulating the manner that church officials are selected. The Establishment Clause, to take one more example, the Establishment Clause would prohibit government from issuing preaching licenses. Look, you have to be licensed to be almost every profession in America, to be a lawyer, to be a doctor, to be a dentist, to be a cosmetologist. But government can't issue preaching licenses. Well, why not? Well, because we never gave government authority over that area of our natural freedom. Okay, in short, a natural rights approach to the Establishment Clause would prohibit government from exercising authority over religious institutions not granted to it, and from delegating its granted authority to church institutions. That is a far too brief overview of the book. I have one slide that, if you want to see the results, I try to produce the results. It's terrible. It's very hard to read, but it will give you, I'll leave it up, and it'll give you a sense of some of the other conclusions I didn't mention. Let me conclude now in the same way I began, which is simply to thank John and Will, all those at AEI, and all those here in attendance. Thank you very much.
Professor Yu?
So after reading Phil's book, I felt like Patton after the first battle in the movie. Patton defeats Rommel, and he says, "Rommel, you magnificent bastard, I read your book." "Phil, this is a great book. You magnificent bastard, I wish I wrote this book." It's a wonderful book. I disagree with half of everything in it, but the first half is great. I mean, it's the most meticulous, detailed parsing of the original sources on the meaning of the First Amendment that I've seen. It's a real contribution, no matter you agree or disagree with the second half of the book, which is more the application. The first half of the book is a real contribution to our knowledge. It's a really impressive, and I can see why it took 10 years. I mean, he has read every single debate of relevance in the founding period. It's a real contribution, so you should be applauded for that. There's some really nice points in there that I had not really been fully as aware of until I had read the book about the founding period. For example, one thing that has really challenged scholars is how do you make the Free Exercise Clause and the Establishment Clause work together? A lot of governments today, in fact, a lot of the cases that Will works on, I think, is where the government uses the Establishment Clause as an excuse to restrict free exercise rights. Like Coach Kennedy, right? He wanted to do a prayer essentially by himself. The school district said no, because if we allow you to do that, we're establishing a religion. Right? So this has been a real difficult. Phil's argument is that the original materials, properly understood, show that the Establishment Clause is almost like a corollary to the Free Exercise Clause. The reason we have an Establishment Clause is to prevent the government from interfering with freedom of exercise of religion. It's a very interesting argument. A second a part of it that really came home to me after I read it, I had read the other pieces, but I hadn't really focused on this, is Phil really connects the free exercise and establishment clauses with the Second Amendment, which is not an apparent connection to most people. Except my parts of Pennsylvania where you can go to church and then shoot things, sometimes at the same time. What Phil says is that the Second Amendment originally had a conscientious objector clause in it, that you couldn't be forced to serve in the militia if you had conscious objection. And Phil shows carefully how that clause was eventually deleted from the Second Amendment. And he has a really good question. He says, if the legislature were supposed to be obligated, or the judiciary were supposed to be obligated to give exceptions to people based on religious objection, then why did they even talk about such a clause at all? Shouldn't they have just assumed that the Free Exercise Clause would have made that provision of the Second Amendment unnecessary? And then he says when they deleted it and never sent that part to the states, only sent the Second Amendment we have now, doesn't Phil says, doesn't that actually show that the founders didn't think exceptions were necessary? In fact, that would just be a decision for the legislature to make, but it's not constitutionally compelled. So these are really important contributions, I think, to our understanding of the free exercise and the establishment clauses. Then there's the other half of the book, which is where Phil, who is not a lawyer, tries to take work away from lawyers by now pretending he's an appellate advocate for the Supreme Court, where he makes very specific arguments that would appeal to lawyers and judges. And this is where I think there can be substantial disagreement. I think, so one way to put it is the first half of the book lays out the facts. The second part of the book is Phil's interpretation of the facts. And he honestly says you could have disagreement with him based on your approach to moral philosophy, which is very hard for lawyers to take in because we have no morals, we just get paid $1,000 per hour. But this is actually where it's hard for lawyers to grapple with Phil's book, because as he just said in his beginning, he said he's not really an originalist because he believes in originalism. Originalism is just a tool, right, that you use to interpret a constitution or give it meaning. But Phil says, I want to know whether the outcomes of originalism are good and just. So I just take one step back and why this is a good place to discuss this at AEI, because this question does involve some of the most important thinkers in the history of our institution. Some of whom were still around when I showed up here. I'm almost on my 20th year here at AEI, and when I was here, Robert Bork was still here. Irving Kristol was still here. The reason they were themselves really interested in religion, and the reason why is because they really struggled with the question of how do we stop the decline of American civilization. There was a fellow named Daniel Bell who wrote a very important book called The Cultural Contradictions of Capitalism. And he predicted capitalism would produce so much prosperity and wealth that we'd all become kind of lazy playing video games and not keep to the moral foundations that made capitalism work in the first place, like working hard and saving. And so people at AEI struggled to figure out how do we solve this contradiction. And so some people religious, some people not religious, came upon the idea, and actually, this is great because Phil is the Tocqueville chair at Notre Dame. Some of them hit on the insight of Tocqueville, which was, can public policy or society itself support those intermediate groups like churches to restore virtue in our republic? And so it came to be that, and you could see this train of thought goes from Bell to people like Kristol, then ultimately I think today Charles Murray in his Coming Apart book. He really shows how these trends in society have continued. And he calls for a lot of restoration of virtues which we might associate with religion. And so this became sort of an AEI product, actually, of the 80s and 90s, was how can we restore virtue? How can we support churches? How can we support religion? Not because, for example, Bork or Irving Kristol were particularly religious themselves. It was because they liked the consequences of a religious country. And I think that's how AEI was really a focus of this before. But notice that it looks at religion as an instrument, not as itself inherently necessarily good, but that religion produces good effects for a religious people produce a good society. So that's how this all kind of ties, what Phil says ties in with what's been happening at AEI and what's been happening with social policy. But then that's also where you might disagree with Phil, because Phil himself, as far as I can tell, does not have a consequentialist view of originalism's outputs. Instead, and I think the most controversial part of the book, which is why if you read all the way to the end, it's really just like the last 10 pages where he really lays it out, which is he's calling for a restoration. I mean, restoration might be too strong because I'm not sure if it was universally held at the founding. Maybe a return to a natural rights approach to understanding our Constitution and indeed our country. And I think this is going to be probably his next book, which is to justify this, because it's not apparent to me why the country would adopt the 18th century philosophy that surrounded the founding. if you weren't originalists, right? You could take this position. We want to know what the 18th century natural rights theory of law and the Constitution was, because that's the background of the Constitution's words. And so if you're an originalist, you would want to give effect to those principles insofar as they appear in the constitutional text. Justice Scalia, for example, did this in the guns case, where he said, you could read the text of the Second Amendment to be a collective right of a militia, but I'm going to read it as an individual right to have a firearm because there's a natural right background of self-defense. Right? He was accused by the dissenters of finding principles and importing them into the text. But he claimed no, because that was the 18th century legal background of the Second Amendment. Right? But that's not Phil's position. Phil's position is that originalism has to satisfy his definition of just and goodness. That would then allow us to evaluate whether his views on the Establishment and Free Exercise Clause should be adopted. That's where I'm not sure the book is as persuasive as it could be, because if you were to take a vote right now, do you think the majority of Americans would be natural rights people? I bet not. I bet to the extent you vote, well, we just had an election today or yesterday. We're still finding the votes in Philadelphia, I think. But if you had an election or you polled people after an election, they would probably be mushy Rawlsians, I would think. So they might believe in some social contract theory, but then a very modern version of it, or a contemporary version of it. They might not like the outcomes. Because here are two outcomes I think people might have trouble with, and then I'll stop, is one, according to Phil, I think there's no right to conscientious objection to anything. So I think Phil would say that if there were a military draft and you were forced to fight, you could be forced to fight even if you were a Quaker or you're Amish, even if the core of your religion was not fighting. I think Phil says there's no obligation to have conscientious objection. The second thing I think that might trouble people who have sort of contemporary moral views would be, as far as I can tell, Phil would say the government can fund every aspect of a church's operations as long as it didn't specifically say church. So suppose the government said, we're going to provide a pension for everybody in the country, including all people who work at churches. That would be fine. We're going to pay for all buildings in downtown. That would be fine. As long as it doesn't single out churches, religious institutions can fully benefit from any government program to the extent that it pays for everything for a church or a religious school. I'm not sure whether people today might necessarily agree with that. And so I think that's the major challenge at the end of the book. And it stops like, how do you persuade people who don't believe in a natural rights philosophy, which I would say, important as it was in the 18th century, I would think is a minority view today, of the justness and goodness of your position, given that that's the metric you yourself set out.
Of course, maybe defense of the idea that natural law and natural rights are well-rooted even today is none of us asked our chairs for permission before we sat on them.
Yeah. Well, I have a chair at Berkeley, so I don't have to ask for anybody's permission to sit on anything.
Well, I did want to, your point about the outputs, I think would be interesting because it would allow us to discuss the natural rights theories articulated in the book juxtaposed with current cases with which the audience might be a bit more immediately familiar. And maybe an initial question there, just to start, as you start with free exercise, is this distinction you're drawing, Phil, between religious exercise as such, which it sounds like you're saying is absolutely protected, versus religious exercise, which isn't. I mean, it could be someone could accommodate it if they wanted to, the legislature could accommodate it if they wanted to, but it's not protected per se. And it sounds like one way that distinction is drawn is you look at the legislation and see if it's targeted. Yeah. Help us understand why, from like a natural rights perspective, why that latter piece makes a difference. Because it would seem to me that it shouldn't matter from a natural rights standpoint, whether the legislature is clever enough to avoid spelling out the restriction on your religious liberty in the law or not.
Okay, very good. Let me start with an example. I mean, that is a very good question, but abstractly put. So let me use just an actual case, a famous case, the Smith case. The background of the case, for those who don't know it, this was from the late 80s, and it was decided by the Supreme Court in 1990. The state of Oregon had a peyote law. Peyote is a hallucinogenic drug. Believe it or not, at the time, Oregon had drug laws. So you couldn't ingest peyote. There was a Native American tribe, the Native American Church is the proper noun, ingest peyote as one of its ritualistic practices, religious practices. This is clearly a church, this is clearly a religious practice. But that religious practice was effectively illegal in the state of Oregon. So Will's question is, well, from the perspective of the member of the Native American Church, it doesn't matter that the state of Oregon didn't target their religion. They effectively made the religious practice illegal. And then John would add, and you would let the Supreme Court or the state of Oregon do that, right? And the answer is yes, that is the natural rights approach. The state of Oregon could make an exemption. The natural rights approach simply says that there's no constitutional right to an exemption. Okay, so then the next question is, well, what does the Free Exercise Clause do then? And that was implicit in your question, so let me try to explain this. The function or purpose of the Free Exercise Clause was to tell the state of Oregon, you can't target the Native American Church and say, you members of the Native American Church, you can't be citizens, you can't practice your religion. We're going to pass a legislation saying no religious practices of the Native American Church are allowed. Now, from our perspective today, our government doesn't do that. Even the state of Oregon doesn't usually do that. But that's what governments used to do all the time. You must be Catholic, or you can't be Catholic, or you must be Protestant, or you can't be Protestant, or you must be Muslim, or you can't be Muslim. And so this natural rights language and the natural rights theory, and I'll come back to the theory in just a second, is significant. In fact, in a way, we live in a natural rights republic, even if we don't understand it, because we actually all do believe that government can't do these things. I mean, the teaching really is deep in our bones. So I don't think it's as bad as what John thinks. Okay, now why is it so limited? And the founders' philosophy is this, that we empower the government to do all sorts of things, to protect our property, to regulate marriage. These are all legitimate functions of government. But we don't give government authority to do everything. That's what it means to have an inalienable natural right. An inalienable natural right is a right you don't alienate. If that's confusing, think of this. The right of revolution is an inalienable natural right. You can't turn over that right to the government to secure. So property is an alienable natural right. Government makes all sorts of laws to regulate wages, to have clear title, right? So we give government authority to make laws to help secure our rights to property, to help us acquire property. But we don't give government authority to help secure our right to revolution. It's nonsensical by the nature of the right. The founders said the same thing about religious liberty, right? That is, we don't give authority to government over our religious exercises as such. So government can't legislate, you must practice this way, or you prohibit it that way. So, and that's reflected, so it's a very narrow but very specific meaning.
Now, what is religious exercise as such?
So what are religious exercises as such? There's two ways that people tend to think about this. What I call a subjective way. I don't use this language in the book, but I think it'll be helpful here. What I call a subjective and an objective way. By subject, I just mean this, that whatever a religious person does, that is the subject of the right, whatever Will does that is religiously motivated is a religious exercise, right? So if Will has to watch football on Saturday and he does it for religious reasons, this happens to people in South Bend, that's a religious exercise, right? So the subject defines the realm of religious exercises. Whatever is religiously motivated behavior is part of religious exercise. An alternative way to look at it is religious liberty is objective. That is, there's an object, a something that's religious liberty or religious exercise. The founders had an objective view. And that's why they could say, we don't give a government authority over this realm of our natural freedom. I mean, so prayer, for example. And I could go further and start using terms from metaphysics, and we'd have to get into ontology, and that would make John very uncomfortable.
You know, I mean, bored.
Yeah. But there's a whole ontology, a whole understanding of reality, and in the founders' understanding, there was something objective that we call free exercise of religion, and that realm of liberty is not given over to the government.
And it wouldn't include sacramental peyote?
So the state of Oregon can make drug laws, because we give the state of Oregon authority over the health, wealth, and morals of the community, but it can't make laws on ritualistic or religious sacrifices. So how you define the laws and the purpose of the laws makes a huge difference.
Okay.
Can I follow up on this point about this question of Smith? Because one thing that troubles me about it, and also troubled when I read Justice Scalia's opinion in Smith, was that it almost singles out religion for underprotection compared to other constitutional rights. So you're a court. You have constitutional rights you're supposed to enforce in the Bill of Rights. If you look at Hamilton and Federalist Number 78, which you cite at length in your footnotes, a court chooses an act of the government, has a case before it where an act of the government conflicts with the constitutional text. And Hamilton and Chief Justice Marshall say you privilege the constitutional text. That's what the court does all the time in free speech, Fourth Amendment, where government may pass a law, but it has the effect of intruding on an individual right. And the court, even if the Congress could or didn't, doesn't matter, could have given some kind of alleviation, an exception to that law for different groups or people to solve the tension with the constitutional right. The court doesn't ask that and then say that reduces our obligation of judicial review. They just go ahead and decide it. So it's interesting. I mean, if you took your theory and applied it to other rights, why does the court, for example, police free speech? Why does the court just say, well, it's up to Congress to provide exceptions for different kinds of speech? It's not our job. We don't have to decide this case. In other words, the Smith approach, when you apply it evenly to other constitutional rights, I think would lead to a lot of results which we wouldn't agree with. So why is religion singled out for this underprotection by the judiciary?
Yeah, I don't have a slide that just has the text of the First Amendment. The answer is textual. The First Amendment says Congress shall make no law prohibiting the free exercise of religion, right? Congress shall make no law, right? It's a limitation on Congress's ability to pass a law. So the point of constitutional violation must be when Congress passes the law, not when a law is applied. That is not when the executive applies the law. Okay, first point. Second point, maybe more important, shall make no law, not shall make no law unless there's a compelling governmental interest. So the prohibition is absolute. It's categorical. Whatever is the free exercise of religion, Congress can't make a law that prohibits it. You can't square exemptionism, that's the Sherbert approach, with the actual text of the Constitution. The exemption approach reads the text to say, Congress shall make no law prohibiting the free exercise of religion unless there's a compelling state interest pursued in the least restrictive means.
No, I don't think that's what the courts do. So first of all, the First Amendment also includes speech and press in the very same language, right? So it says Congress shall make no law, right, about speech or press. And those are areas where the court is very happy to exercise judicial review to stop laws that it feels, even if they're not passed to restrict speech, if they have the effect of restricting speech, the court still will block those laws. So I don't think the text gets you out of it. And this is the point. it's not like whether natural law exists or not with regard to limiting the right. I'm asking more about the obligation of courts when there's a conflict between a constitutional text and some action of government. And this is also originalist, I think, is the judiciary is not expected to enforce unconstitutional laws. And so if it forces, for example, the Oregon, I think it's a Native American tribe, to stop using peyote under threat of criminal law, it's choosing an act which it thinks is unconstitutional over the constitutional text because it's saying, oh, this other institution will take care of it.
Yeah. You're presuming that the citizen of Oregon has a right to use peyote for religious reasons. That is, you're assuming a subjective understanding of the right, right? That because I'm using peyote for religious reasons, that's part of free exercising. I'm denying that that's part of the constitutional right, right? That the nature, the scope of the right doesn't include all religiously motivated action. No, we might not like that. We might want all religiously motivated action to have some sort of protection. And it can if we pass legislation like the Religious Freedom Restoration Act. But that's not how the founders understood the right. Our disagreement is actually what's in the right.
So could I, given...
Can I say one other
thing? Sure, please, go ahead.
There's something else that's important, an important point to make. We have to remember that the Bill of Rights is not meant to solve all injustices and all problems. And judicial review and the courts are not meant to protect all of our liberties, right?
We can all agree they make things worse, usually.
Yeah, the founders' constitution, the Bill of Rights had, it's a small part of the way our liberties are protected. The way that peyote users in Oregon are protected is primarily through representation, right? That is, don't pass laws that have the effect of burdening the citizens of Oregon. Or if you do, grant an exemption to them, a legislative exemption. These are all how our rights, other ways our rights are protected. The First Amendment, enforced by the judiciary, has a narrow role to play. It's a very important role, but it is narrow. And sometimes we think is, if the First Amendment doesn't protect the right's not protected. But that's just a misunderstanding of our system of government.
So could I ask you, though, about, you said, if I misunderstood you, unless I misunderstood you, that sacramental peyote is simply outside the scope of religious worship as such. And if that's right, then would it even... go ahead.
No,
it's not right.
So the government of Oregon has authority to pass general drug laws. Mm-hmm. If those general drug laws incidentally burden some religious believers, that is unfortunate in my view, but it's not unconstitutional. The state of Oregon couldn't pass laws prohibiting this form of religious worship.
Right. And what if, okay, we've talked about...
Here's a better way to put it. What if the practice that's barred by the state is actually the central core of the religion? So take the Quakers.
Yeah, the Quakers.
What if the Quakers are forced to fight in war? You would allow that.
Yeah, so this is your question, right? I mean...
Well, it was part of it because one of the issues I see with this here is that you could... I'm not even sure what the role targeting would play if you think that the practice at issue is not part of religious exercise as such. The legislature could be as explicit and as hostile as it wants. It wouldn't matter because it's not part of the right in the first place.
As long as it's otherwise valid law, like drug laws and things like that. The Quakers, I think, so students always ask me this, so you're going to make Quakers fight. Yeah. Usually,
the war would be very short, but it would still be interesting to see them fight, yes.
Yeah. So think about why do we have a political community? Look, the most basic thing a political community is, it's a mutual defense pact. I won't attack you, you don't attack me. I'll fight for you, you fight for me, and we'll fight against our common enemies. That's the most basic thing it is. It's a mutual defense pact. And the Quaker says, effectively, I want to be part of that pact, and I won't fight. The Quaker doesn't have to be part of the pact. You have an inalienable natural right to immigrate, that is to leave. But if you're going to be part of the club, you got to fight if asked to. Now, we can say, look, you can do something else. You're probably not going to be a good soldier anyway, so we're going to give you an exemption. But you don't have a constitutional right not to fight. And there's no injustice there. This gets to the point, this gets to the part that Professor Yu doesn't like when we talk about justice or not, right? It's not unjust to make someone do their duties as a citizen. We need to think very carefully about what things we require, what things we prohibit. We shouldn't be making all sorts of laws that prohibit the religious exercises of all sorts of individuals. Those are bad laws. But just because they're bad or they have bad effects doesn't mean they're unconstitutional.
There's one more point on this before we move on to the Establishment Clause, because I want to make sure we have time for audience Q&A, is there's some more recent cases that the Supreme Court has dealt with involving Blaine amendments that I think raise some real challenges with this approach, because on the one hand, the statutes usually involve prohibition on aid to, quote, sectarian institutions, which if you look at the legislative history, I'm not sure if you should do that on your view, it's pretty clear that these were motivated by anti-religious bigotry, and there's a long tradition of that, but it's not on the face of the law. You could imagine sectarian doesn't mean that. It often comes up in the context of religious education, which maybe that's not religious exercise as such, so it shouldn't matter that religious schools are being excluded from equal benefit programs. And then I think about, there are even cases like one we talk about in the book, Lamb's Chapel, where New York prohibited a church from using a public school facility after hours to show a movie about family life issues. And it said that it was under no obligation to put the church in the public school because the statute didn't allow for religious uses. That statute didn't say anything about religion, one way or the other. So I'm just wondering, like, how do we think about these issues that involve religious education or have nasty legislative history or say nothing about religion at all, but affect what a church is trying to do?
Yeah, very good. Well, let me go back to one of the points John made, that many of these laws that are explicitly discriminate against religion, right? Everyone else can apply for these funds except you, religious group. Because you're religious, you're excluded. Many of these laws are passed, at least more recently than the Blaine Amendments, because the states say to comply with the Establishment Clause. The court, starting in the 40s and especially in the 70s, read the Establishment Clause to require discrimination against religion. I think that's wrong, and I think that's inconsistent with the original meaning of the text or the natural rights approach I set forth. So one of the reasons we have so much discrimination of religion is a misreading of the Establishment Clause. John pointed that out, and so I think if we read the Establishment Clause properly, there wouldn't be the reasons to eliminate religious participation. Right? And that doesn't solve all the problems, but that would solve a lot of the contemporary problems. I mean,
but that would just make it okay for a legislature to accommodate a religious school if it wanted to. It wouldn't say a religious school has a right to participate equally with everyone else, right?
If religious groups have an equality right or a non-discrimination right, I don't think it's through the Free Exercise Clause or the Establishment Clause. It could be through the Equal Protection Clause or privileges and immunities. There might be other reasons. I actually think equal protection, but to be treated equally is not the work the First Amendment was trying to do. It might be, I think there is an equal protection element, and I think discrimination against religion on account of religion is problematic. But again, that's not the original purposes of the First Amendment.
Since we're about to move to questions, there was something I forgot to say in my comments, which I just wanted to point out, and Phil keeps suggesting this, and Will's questions do too, is where does Phil's outcomes match up with the court's current jurisprudence, where the court's going? So Phil, I'd say, is very principled. I think the justice you come closest to is Justice Scalia. Right, with Smith, this kind of courts should generally get out of the business of creating exemptions for religious laws, and also the later Scalia in terms of the Establishment Clause. We should stop striking things down on behalf of the Establishment Clause. For Scalia, but it's an interesting difference. For Scalia and for AAI, I think as a whole, it was skepticism about the judicial role to make these choices. For you, it's a very different reason. Right? I think your view is rooted more in political philosophy rather than any kind of discussion of the competence of courts versus the executive or the legislature. But I want to say that this is a very interesting part of Phil's book. There's a whole chapter where he just basically goes through every major religion case of the last 30 years and just systematically goes through how they line up with what he says is the proper natural rights understanding. And the last thing I'll say is it's admirable in that in some places he reaches what you might call liberal outcomes, for example, with Smith. In other areas, he's much more conservative than the current Supreme Court, particularly on the Establishment Clause. And so I actually think, given that there's this new conservative majority on the court and they are taking a lot of religion cases, this might be one of the defining features of the Roberts Court in the end. The book is actually trying to provide a theory for a court that sort of wants to overrule these precedents, but they don't know why they dislike those precedents so much.
I think that's very perceptive, the connections to Scalia. But Scalia's church-state jurisprudence, I don't mean this globally about Scalia, just on church-state, he was very good at critiquing what he thought were bad decisions and not historically grounded. And I think those critiques were devastating. He was never very good at explaining, okay, this is what the Establishment Clause actually means, or this is what the Free Exercise Clause actually means.
Well, there's only so much time in the day the poor guy had.
Well, that's something I wanted to ask you about, because there are some opinions from Justice Scalia you do depart from the Establishment Clause context. The one most notably would be Lee versus Weissman, which involved prayer at a graduation ceremony. But it gets to this broader methodological question in the book, which is about the role of history and tradition in interpreting the Establishment Clause. You seem to say there shouldn't be any role, which is very different from where the current court is, right?
Well, the current court, you see this in Justice Alito in particular, says, look, we don't know what the Establishment Clause originally meant, but we can use as a proxy for the original meaning early founding era action. So if there was a legislative chaplain in the first Congress, prayers in public places, government-sponsored prayers, since the founders did those actions, we can assume that those actions are consistent with the original meaning. But the founders did other things too that clearly were not consistent with our principles. And the liberal here would say, well, look at slavery. Look, almost every founding era state except Virginia had religious tests for office. You had to be a Protestant to be governor in Massachusetts. Every single state except Virginia. Well, why aren't religious tests for office therefore okay now? Sometimes the court invokes tradition, sometimes it doesn't. It doesn't always invoke tradition. And you have to have a reason, so why are these traditions okay and those traditions are not? But that points beyond tradition.
So what about Thanksgiving Day proclamations? Those are coming up. Are those constitutional?
James Madison said official Thanksgiving and prayerful proclamations by the president acting in his official capacity were unconstitutional.
The pardoned turkey is probably very happy.
Yeah. Some principles are not always perfect. The rule of law is not always perfect. But it's worthwhile to go through the intellectual exercise to try to understand what the principles would produce. Good politics is not perfect, but you still need to understand the principles, I think, especially if you want to have a principled jurisprudence, which I think would be much better than the type of jurisprudence we have.
Anything? Seems like a good opportunity to open it up to the audience for questions. Please wait until a microphone is given to you, and please have your question end with a question mark. Yes, back there, please.
J.P. Hogan, you seem to have a difference on the Second Amendment. I've been thinking about that for a while because it seems like they may have done a workaround and used a free state as a moral standard. And the Second Amendment would be a clause to the first ends of government and grievances. So if you read the two together, they may have created the moral standard, whereas you have a right to bear arms if you're for a free state for all, if you're for the moral purpose of the country. I'll try to keep it that simple.
The Second Amendment context here is just in the drafting of the Second Amendment. It's a complicated point. Since I started with this is the Justice Alito. If you want the opposing view, you can read Alito's opinion in Fulton, because this is a piece of evidence he did not like. Let me just put that out there. When they're drafting the Second Amendment, which is about the right to bear arms, there was a provision that said, basically allowing for conscientious objection. And the worry was that that when you, in the context of the right to bear arms, there was going to be a military draft, right, that you'd have to bear arms, and what about the Quakers and others? So they had an exemption in the Second Amendment. The Second Amendment was drafted at the same time as the First Amendment, on the same day. In fact, they drafted the First Amendment, free exercise, and then they drafted what became the Second Amendment. And then there's, in the context of drafting the Second Amendment, they said, well, what about the Quakers? And they did this right after they adopted the First Amendment. And my point is simply this. If the free exercise clause granted exemptions, that is, as the First Amendment granted exemptions, why did they have a big debate over the matter when they drafted the Second Amendment later that afternoon? And no one said, oh, we took care of those exemptions when we drafted the First Amendment. Now, this is just an inference from a sparse record. You don't want to make too much out of that. It's just one small piece of evidence, I think, that suggests that exemptions were not part of the original understanding of free exercise.
And there's some Mike McConnell, who you criticize in your book, says basically you don't need to have it in there because everyone agreed there would be exemptions. And this is a problem with legislative history, is how do you treat silence, essentially? You delete something, does that mean they agreed with it, or they delete it because they disagreed with it? Yeah.
Judge?
The microphone is coming to you. The microphone is coming to you, yeah.
On the history and tradition point about, you used the religious test as an example. True, you had religious tests in the states, but the reason we don't have them for the federal government has nothing to do with the First Amendment. There's a prohibition of them in the text, in the Oaths Clause, right? So there's got to be a better argument than that about Marsh, right? So it is true that there were things that were allowed at the time of the founding period. So the Alien and Sedition laws, for example, but it was highly controversial. You know, Jefferson pardoned everyone convicted under that law, refused to enforce the law, refused to prosecute any cases. A highly controversial type law. There was no controversy about the chaplain.
Yeah, the judge is making reference to the legislative and military chaplains. Well, James Madison did say that they were unconstitutional. So, I mean, that you're right, they weren't controversial, but not everyone. You know, the father of the Constitution thought they were a mistake. Yeah, but also on the religious test for office, the Supreme Court did strike them down for states in McDaniel v. Patty and Tacasso in the 1960s.
There's a prohibition in the federal Constitution. The point is.
Yeah, but if we relied on tradition alone and said whatever the founders did, it would mean that religious tests for office via incorporation, that states could have religious tests for office. My only argument is tradition isn't enough. It's a piece of evidence, but sometimes the founders actually, their traditional practices were in conflict with the underlying natural rights principles. And if you take a natural rights approach, then those traditional practices would be struck down.
Of course, there's a risk there, right? That you could be a court and just say, well, we've reasoned better than the founders. Right?
That's always a danger, right? That's always a danger, and it's a danger that I think that Justice Scalia in particular was leery of. But it's hard to have a principled jurisprudence if you're not willing to have principles, and principles are a product of reasoning about things.
Yes, sir. Just wait just a moment for the mic.
Thank you. Thank you. Thank you. David Sobelson is my name. Cases involving religious freedom typically apply the 14th Amendment to state and local government action. What type of bias does it introduce into the analysis to impute to the drafters of the 14th Amendment the views of their grandfathers 80 years earlier about what they meant in drafting a different part of the Constitution?
Yeah, that's a terrific question, and it's something that I struggled with. So, and let me give you the context on how I struggled. It's pretty clear to me that one of the original purposes of the Establishment Clause It was really about federalism. Here, Justice Thomas is right. And the textual language is, Congress shall make no law respecting an establishment. If we passed a law today and said, or someone just said, Congress shall make no law respecting abortion, we would all understand what that means. Well, Congress can't make a law on abortion, right, whether for or against. Well, who can? Well, the states. And that language, Congress shall make no law respecting an. In fact, the phrase respecting an is only used one other place in the Constitution. I want to ask our judges here if they know where. Judge Duncan says, where are my clerks? Yeah. Congress can make laws respecting the territories. Congress is given plenary power over the territory. Respecting an is a jurisdictional phrase. Right? Congress shall make no law respecting an establishment. Establishments, whatever they are for the states. And that actually tracks with the anti-federalist concerns about consolidation and nationalization. So the gentleman's question is, well, how does the 14th Amendment, and how do you apply a law, a provision, the Establishment Clause that's meant to protect the states against the states? Well, the answer is you can't coherently without at least erasing the federalism component. And so that's a real problem. There are books waiting to be, if Justice Thomas starts writing more and more opinions, we'll start having books on disincorporation. But no one but Justice Thomas has been willing to go that far. The way I deal with it in the book is just acknowledge that you can't apply this part of the Establishment Clause coherently. What you can think through is, okay, but the federal government can't establish a religion. That's also part of the original purpose. What is that? What would that prohibit? And that's where I get to the state establishments and church establishments. And you could apply that against the states. That's not the original, consistent with the original purposes. Whether it's consistent with the original meaning of the 14th Amendment is beyond the purview of the book.
Can I follow up again? Since you mentioned Justice Thomas, in Dobbs, he said, in other opinions, he said the real root of the rights in the 14th Amendment is the Privileges and Immunities Clause. Do you think that the Privileges and Immunities Clause includes a right not to have a state set up a religion?
Yeah, I would go back to actually what you said earlier, that establishment really is, the reason you don't want establishment is actually because it violates free exercise. It tends to. So really the privilege and immunity is going to be free exercise. Establishment is just a way to prohibit certain types of institutional arrangements. It's not really an individual right at all.
That's why it doesn't make sense as a privileges and immunity.
Yeah, I think that's right.
Well, there's another institutional aspect of Establishment Clause, and you get into it a little bit in your book. It involves church autonomy and the ministerial exception, and that prohibits courts from essentially second-guessing a religious institution's choices over ministers. How far do you see that? If our ministers, where do you see that all shaking out in terms of the religious worship as such? I mean, would be choices about religious curriculum or religious school teachers, would those be protected decisions?
So the church autonomy line of thinking, or the ministerial exception, I don't think the natural rights approach would actually reach the same results, though it overlaps to some degree. It says the government can't instruct churches on how they must appoint their ministers. I mean, this is a quintessential Establishment Clause issue, right? It's the king appointing bishops, right? That's an establishment, and that's prohibited, right? So the governor of California doesn't have any say over the Archbishop of Los Angeles.
We better let Gavin Newsom know that right away.
Okay. So there is an overlap there. Where there's not an overlap, and candidly, this is one of the results that I think is a result from principle. I don't much like it, but it is what it is that general non-discrimination laws, assuming they're otherwise constitutional and valid, would apply to churches. I don't like those results, right? It's a deep problem. I'm Catholic, it's a deep problem for the Catholic Church. So maybe there's a problem with the non-discrimination laws as applied to everyone, and we should think more clearly about non-discrimination law. But there's no First Amendment right, at least in this approach, that would shield the churches from those laws. So you couldn't have legislation saying government officials have the right to appoint ministers, but general employment regulations would still apply to churches.
So one, I'm not seeing any other audience questions, so one just follow up on that. It seems interesting. Part of the argument for Smith, certainly, and it comes through a little in your book, was a respect for judicial restraint and a limited judicial role. If you agree with that, how do you think about the fact that it sounds like, on your theory, courts would be free to essentially determine, was this religious exercise as such? Was this just religious exercise? It's not really central to your religion, it's not within the right? Are those the kinds of questions that would come from your view?
No, because the courts actually wouldn't be looking to the religious individual, they'd be looking at the text of the laws. That's what they would be examining, right? And that's what they should be examining, actually. They'd be looking at the statutes themselves, not the effects of the statutes on the individual. So there's no actually inquiry into, is this central or not? Does this law, we're only examining the law, right, take cognizance of religious exercises as such. That's an objective understanding of religious exercise. There are things we know that are part of religious exercise. And you'd see it in the text, right? Are you regulating the Mass? Are you referring to a religious group by name? So actually the inquiry would be far simpler in terms of functionality of judges being able to do it.
Adam?
I'm Adam White, AEI. Could I follow up that question? Because I wonder, to the extent that legislatures could pass laws that are on their face generally applicable, but in their application they cover predominantly, almost exclusively a religious community, those sorts of laws might be motivated by an intent to burden the exercise of religion. Would the judicial role there require an inquiry into the motivation of the legislatures? You said a moment ago they're focusing on the text, but I wonder about that.
Well, look, if it's, I think there is room for sort of pretextual analysis. Like if you're clearly trying to get at these people, but if you actually can comply with, if you can make it an otherwise valid law, that's often not as easy as it seems. But if the law is actually otherwise valid, then it's valid. It might be a bad law. It might be a reason to vote the legislators out. It might be a reason not to pass the law or to rail against it. But again, the Constitution doesn't protect against all bad laws. So let me just say one thing about the approach. It's very democratic. It actually says that we, the people, through our elected legislatures, can do all sorts of things to support religion or maybe even to limit religion. We don't have to do those things. And the main way our rights are protected actually is by electing wise and responsible legislators who will actually legislate for the common good and be sensitive to the interests of the people. Right? That's what living in a democracy or in a republic is. The argument for living constitutionalism actually is, well, the government does so much more now, with the administrative state, that we need to equip judges to interfere with these democratic choices. That's how we get exemptions in the first place. Right? William Brennan is the author of the Sherbert test. So many of the arguments I hear from conservatives about, well, government does so much more, we need to change expand the protection of our constitutional liberties. There are very good arguments for that, and it's called living constitutionalism.
Maybe.
Can I follow up, tie this to another area of interest for AEI, which is the administrative state, which you mentioned earlier, which is a lot of these laws have almost no text at all. Right? They just give enormous power to the agencies. And the agencies are when they give you permits and permissions to build that church or construct this dam or whatever. And so there's no law actually for courts to examine. You've left it all in the hands of these administrators, whether to grant the exemptions or not. And there's some people who think that's great, right? Because they're wiser than your very inspirational but naive view of the legislature and how it works.
Okay,
You can get the last word to defend your very inspirational but naive view.
there's actually, I thought this was a point that Professor Yu might make. I'll give you what I think is the best argument against this approach. I give a natural rights approach for part of the First Amendment. I think it's an open question. Does it make sense? Is it coherent to have a natural rights approach only for 2 clauses in the First Amendment? The Constitution was designed to protect natural rights. But if all these other elements of the Constitution have been distorted, are not interpreted in a natural rights manner, does it make sense to interpret the First Amendment alone in a natural rights manner? Right? Because we have all these other distortions, the administrative state, delegation of power, the Commerce Clause, right? The First Amendment is part of a whole. And so when I say the First Amendment is limited, right, I think that's true. But a limited First Amendment is part of a larger package of other constitutional provisions. So it's really an open question to me if it's coherent to do natural rights originalism only in piece, piece by piece. Really, you need a natural rights approach to the entire Constitution. And I think the book would make much more sense if the rest of the Constitution was interpreted in a natural rights approach as well.
Ending on an open question seems like a good invitation to go visit the table where we have the books. The book is Religious Liberty and the American Founding. The author is Professor Phillip Muñoz. It was a great pleasure being with both of you this evening. Thank you very much.